Hi, I'm attorney Gregory Dell, and I'm joined today by attorney Rachel Alters, and we're going to talk about long-term disability insurance denials and what to do if you find yourself in this position. Rachel, lots of times people call, they just got their denial letter, and fortunately they've never been in this position before, so they have no idea what steps need to be taken. So in this video, I want to provide some guidance as to what the road ahead is going to be after a long-term disability denial, and provide some tips as to how to handle these particular types of disability insurance denials. And so just to be clear, in our video, we're talking about long-term disability insurance claims, and we're not dealing with Social Security disability benefits here because there's a significant difference between the two. So when a person calls you and they say, I'm calling you because I've been denied, what are my options? What are the first things that you need to know, Rachel?
When a person calls me, Greg, with a long-term disability denial, they ask me, okay, I've been cut off, I'm no longer getting my monthly benefits, what do I do? And I ask them first, is it a group policy that you receive from your employer, or is this an individual policy that you bought on your own? It's very important to know whether or not, the person bought the policy on their own, because there's a complete different set of rules for the long-term disability appeal. So when you have a policy that you received from your employer, from your place of business, it's governed by ERISA, and usually with most insurance carriers, you only get one opportunity to appeal. So the appeal has to be done correctly because you don't get a do-over, and the appeal is essentially your trial. So it's really important to know, is this an ERISA claim or is this an independent claim? Because with individual policies that people buy, when they get cut off, they can do an appeal, but it's not necessarily it's not necessary. So sometimes the appeal can be done in certain situations. Other times you can go straight to court.
And so what are the basic differences between a claim that's governed by ERISA, and if you can basically explain what ERISA is, and then a claim that's not governed by ERISA?
So, Gregory, the difference between a group policy and an individual policy is the group policy is governed by ERISA, which is a federal act that is the Employment Retirement Income Security Act that was enacted in 1974, which essentially is supposed to protect employees, but it really does protect more so the employer. And it sets out many rules and regulations as to how these disability claims are governed. So, if you have a claim or a policy that's governed by ERISA, then you have to follow all of these rules. And when you get denied, you have 180 days to appeal the denial of the claim. Once that appeal is submitted, and you must be sure to submit that appeal within that 180-day period. If the claimant doesn't submit the appeal on time, then they lose the claim altogether. So this is a very important fact to remember. And once the appeal is submitted, hopefully with the help of an attorney, then the insurance carrier has 45 days to make a decision. They also can request an extension for another 45 days, and now there's a bunch of loopholes that can get them more extensions depending on if the carrier asks for additional information. So it's a lengthy process, but it's very important that it's followed to the T. Otherwise, the claimant can lose their right to the benefits that they may be entitled to until they're 65 years old.
And then, Rachel, also there's a whole set of 20 pages of what's called ERISA regulations, which the disability insurance company must comply with when conducting their review, whether it's an initial application, whether it's the appeal of a denial from a claim that they've denied. So those regulations have to be complied with as well, which make this a very complex area of the law, and also make it difficult for claimants because if they don't understand all of the laws and they don't have a strong strategy as to what should be an appeal or what should not be an appeal. The other thing, Rachel, if you can talk about the difference where if you're denied on an individual disability claim, do you have to file an appeal, and what are the available remedies for someone in that position?
Yeah, it's quite different when it's not governed by ERISA, because when you buy the policy on your own, you have a lot more rights. When you buy an individual policy through an insurance carrier, you have the right to a jury trial. you have the right to sue the insurance carrier without actually having to go through a lengthy appeals process. And this can be a big advantage to some claimants because unfortunately, when these are group policies, there are even certain insurance companies that require that they file 2 appeals before they can even get to court. So when that happens, if you can imagine, if you have a 9-month appeal process and then another 9-month appeal process, that's a good 18 months. That's a year and a half before the claimant could actually file a lawsuit. Where when you buy a policy on your own and you get cut off, the claimant has the right to file suit immediately in state court. They don't have to be in federal court. They have a right to a jury trial. They can get other damages outside of what ERISA provides. ERISA provides only damages for past benefits and possible attorney's fees. If you have a private policy, you can possibly sue for bad faith, maybe punitive damages. There's a lot more options for a person who has a policy that they bought on their own. So that's a very big distinction. Now, there are times and situations where I've had a client who has had a private policy and the insurance carrier will give an opportunity to appeal the claim and to appeal the decision. And we do go forward with an appeals process. It just usually takes a shorter amount of time. There aren't as many rules and regulations, and it doesn't take usually the full 180 days plus another 90 days plus to get a decision on the claim. And if you don't get a decision in a timely manner while you have a private policy, you could just go ahead and go right to court. Where in a ERISA case, it's very difficult to do that. You can file a lawsuit in an ERISA case if the insurance carrier hasn't followed the proper ERISA guidelines. However, oftentimes that gets kicked back due to some sort of, whatever the judge decides, that they think that they haven't exhausted their administrative remedies, they may not allow the lawsuit to go forward. So there's very big differences in a group policy versus an individual policy when it comes to litigation.
So, Rachel, if you can remind the person who's watching this video, because you've bounced back and forth very skillfully between the ERISA benefits and the individual disability benefit, pro and cons. But how would a person know, am I governed by ERISA or am I governed or not governed by ERISA?
That's a very good question, Greg, and sometimes it's not always black and white, but generally speaking, if you have an employee policy that you receive from your employer where the employer paid for the premiums and it's basically given it to you by your employer and it's a group policy that everyone at your office is covered under, that would be governed by ERISA. Oftentimes some employees will pay some of the premiums themselves. That doesn't take it out of the ERISA realm. It's still governed by ERISA. So anything to do with the group policy that's given by your employer is governed by ERISA. Now, there are some loopholes to that. If your employer happens to be a state or a county or a public university or a public hospital, most of those are ERISA exempt. So those are not governed by ERISA. They fall under those guidelines, and then you have different rules and regulations that will apply to you. But if you don't work for the government, you don't work for the state, you don't work for a public university, then 90% of the time your policy is going to be governed by ERISA. Now, if you buy a policy yourself with an agent outside of your employer that has nothing to do with your employment, then yes, those policies are not governed by ERISA. There's different rules and regulations for those, and you have a lot more rights, a lot more things that you can do with a private policy than you can do with a group policy.
Right, and also the other group that is often exempt from ERISA is the association group. So if you have like an American Dental Association, American Bar Association, any type of organization that you may be a member of where you're not employed by them, but you just happen to be a member, then those are often exempt from ERISA as well. So that's another type of group policy that isn't governed by ERISA. And then Rachel, since we're talking all about what to do for disability denial, and we have extensive and lots of videos on ERISA appeals and lawsuits, whether it's ERISA or not ERISA. So we encourage you to search our YouTube channel or search our website for the situation that's specific to you. But Rachel, just touch on it briefly. Why is it so important when, if you do have to submit an appeal required by the ERISA laws, that it's done as strong as possible?
I was just explaining this to one of my potential clients this morning who has an appeal that's due with MetLife, and MetLife is one of the insurance companies that requires, only allows one appeal. So when you have one appeal, it's essentially your trial. So you are putting on your trial in front of a federal judge through the appeal process before you even get to court. Because basically what you're submitting in your appeal, which whatever that may be, we do this all the time, so we know exactly what needs to go into an appeal. We know what the medical records need to say. We know what testing needs to be done and what the forms need to be filled out by the doctors and the language that needs to be put into them, because once that appeal is submitted, unless it's overturned and you're approved by the insurance carrier, if that appeal is denied, then you go to court and a federal judge is looking at that appeal and whatever else is in that record. So that's your trial. So it has to be thorough, it has to be very complete. It should be done by an attorney, especially when you only have one shot. Because at the end of the day, if you forget something in that appeal, once that determination is made and the administrative record is closed, you can't add anything. So something could happen the day after. You could get approved by Social Security. You can get into a car accident. None of that comes in. The judge will never see that, won't consider it unless it was submitted with the appeal. So it's extremely important that that appeal is written as well as it possibly can by a lawyer who is experienced in this area.
So Rachel, just to clarify and give another extreme example, you do an appeal for somebody, the appeal gets, you lose the appeal, and then you go ahead and file a lawsuit. But between the period of time of when you submit, once you've finished your appeal, the insurance company made a decision, the claimant has some kind of surgery. Can the court consider those surgical records?
No, unfortunately not. Once that appeal is submitted and the insurance company makes the determination, that surgery is like it never happened. The only way that surgery can come in down the road is if the claimant goes through a full trial, the judge rules in the claimant's favor, then the claim gets remanded back to the insurance carrier for another review, and then at that point, then those records can be submitted. But this is a very rare instance where, oftentimes, the claimant isn't winning the trial, and if that trial is not won, then it never comes in. So it's really important that everything gets submitted during the appeals process.
Okay. So Rachel, obviously we represent people during the appeal process where we help them submit these appeals so that they could be as strong as possible. And then we also represent people who've already done appeals on their own, and the only remaining remedy at that point in time is to file a lawsuit. Can you talk about what the expectation is and what the standard of review is usually for somebody who then has to file a lawsuit because that's their only remaining remedy?
Sure. So when I get a call from somebody who's done the appeal on their own or had another lawyer do the appeal, but they don't handle the lawsuits, and this happens all the time, I'm happy to help them file the lawsuit to represent them from that point on. Obviously, I have to use whatever was in the appeal and what's already in the claim file. I can't add anything else. However, we are really good at creating a case and using what we have going forward. And when you file a lawsuit in federal court, it's governed under ERISA, so it's going to be one judge reviewing the claim. There's not going to be any testimony. They're not going to, the plaintiff is not going to be able to testify. They're just going to review the claim file, and the judge determines whether the insurance company was arbitrary and capricious in denying the claim, which in layman's terms means that the insurance carrier didn't even have one reasonable basis to deny the claim. It's a very high standard of review. So these are often very hard to win. It doesn't mean that we can't win them. It's just very difficult because if the judge finds that the insurance carrier had one reasonable basis to deny the claim, then they're going to rule in favor of the insurance carrier and the claimant loses. So what we have to do is prove this, that there was no reasonable basis to deny the claim, that they were arbitrary, capricious, and we do that through reviewing the claim file, looking at the peer review physician, making sure that they were qualified to do the peer review, making sure that the insurance carrier didn't violate any of the ERISA rules and regulations, and if they have, then that's how we make our claim. Now, a lot of the claims that we file in federal court, there's a large percentage of them that will settle for a lump sum settlement before we ever get to the judge. And that happens a lot of times because both the insurance carrier decides it's not worth their risk to go all the way to court, and the claimant also decides, they're better off settling the claim, because if they go to court, there's a high chance of losing, or they may not have that large of a benefit to win. So that's the risk that we discuss, and oftentimes it will go through a lump sum settlement and everybody walks away basically happy.
And then Rachel, that was a good quick summary of what to expect in a lawsuit, and you talked about the arbitrary and capricious standard, and we also argue, not to try to get too technical here, but we also try to argue for a de novo review, which is the most favorable for a claimant, where the judge can look at it on his or her own and make a determination as to whether or not the claimant's disabled or not. And some states only allow for a de novo review, which is great, while there are arguments that we always try to make to tell the judge that it should be a de novo review, and we're happy to discuss those different thresholds with you when we speak to you. And then Rachel, I wanted to just touch on this about time frame, that all of the ERISA cases have to be filed in federal court, that we file them in federal courts all across the country, no matter where you live, and that the reasonable time frame is usually anywhere from, and it's a big spread, anywhere from 6 months to up to 18 months until there's a resolution. And a resolution, Rachel, as you said, could be a lump sum settlement, which is a direct offer from the insurance company to buy you out of your claim. Or it could be that you have to go through a whole entire lawsuit and get a verdict in order to get paid. And even if you do get a verdict, it's possible that the judge could remand the case back to the insurance company and say, you acted unreasonably, and I want you to review the claim again. And it's not a real win. I mean, you're still alive in the sense that you have a chance, but the insurance company gets another bite at the apple. And hopefully the judge gives instructions to say, I think you were wrong. I basically am saying the claimant's disabled, and my instructions are that you should calculate benefits and pay the claimant. But the judge could remand and say, I think you need to do another review, and you have to go through that whole appeal process again and file a lawsuit, which is very timely, and all this time the claimant's not getting paid, which is the worst part about this all. So if you have been denied your long-term disability insurance claim, we encourage you to contact either Rachel, myself, any of our lawyers. We will provide you with an immediate free consultation. The only thing that we're going to need in order to conduct this review is a copy of your denial letter. So we encourage you to click the free consultation on our website or give us a call, and we'll give you information to email us your denial letter. We also encourage you to take some time and review our website, look up your company, look up your medical condition, look up your occupation. You're going to find all kinds of cases that our lawyers have handled, as well as lawsuits that we've summarized. And we want you to be really educated about this process, because the better educated you are, the better position you're going to be in to not only win your claim, but also to keep your benefits from being denied in the future should you win your appeal or your lawsuit. So no matter where you live in the country, we look forward to speaking with you should you need us in the future. Thank you.